Well, let me introduce myself. My name is Steve Ryan. I'm a lawyer in Washington, D.C. I've been a member of the bar for 27 years, and I'm still practicing. I served the United States government for about half my career. I was an assistant United States attorney prosecuting people in the District of Columbia. I was an organized crime prosecutor prosecuting people in La Cosa Nostra, Chinese organized crime groups, and in the Teamsters Union. So I don't scare easily. I ended my career as Chief Counsel of the United States Senate Committee on Governmental Affairs, where I learned how to be an Internet lawyer. I decided at that point that it was better to be a broken-down Internet lawyer than it was to be a broken-down white-collar criminal defense lawyer, and I made my switch to this technology. So this will be a little bit more interesting, I hope, and I hope that you'll get ready for, I'm going to leave a lot of time for questioning, and I don't mind if you challenge me as long as you do that politely. And I'm going to want everybody who challenges me to say who they are and whether they're a legacy address holder.
And what their block is?
And how much of your block is actually in use. With that, to show you that I have a partial sense of humor, and to bring you back from the usual stupid jokes that you tell, like, you know, what's 150 lawyers at the bottom of the ocean, a good start. These are the sort of more elegant jokes about lawyers. And my favorite really is the first one. You know, we lawyers can fight with one another very politely. And so one night Daniel Webster was debating for the soul of a New Hampshireman against the devil. And at one point, as lawyers do, the two went to the bar together, the devil and Daniel Webster. And Daniel Webster really marveled at the devil's knowledge of the law. And he said, "Sir, where did you come by that?" And the devil answered, "Well, where I come from, we always get the pick of the bar." My other favorite is Governor William Langer, who was a governor in the 1930s in one of the Plains states. And his quote was, "If you put a banker, a lawyer, and an industrialist in a barrel and roll it down the hill, you've always got a son of a bitch on top." There are ways to insult us that are better than the ones about no skid marks and why we use lawyers because the people become attached to the rats, you know, that sort of thing. And so finally, I'm going to do this a little bit like a black church. I'm going to require some audience participation, and I'm going to be looking to you to look up from your email and your internet. The assigned reading for this course while we're here together is RFC 2050 and RFC 2008. So I'm going to assume that all of you who are looking down, which is most of you, are going to be reading 2050 and 2008 while I'm up here. All right. Off we go. Let me just say that you are part of a very interesting experiment. Around the world, there are governments that don't believe that this room is a meaningful room. This room contains the people who actually make the internet run. And in a lot of countries, there are governments that would like the controls that are currently distributed in part to non-governmental organizations to be taken back into governmental control, both on a national and international basis. So right now, there's an interesting experiment in internet governance that's going on. None of us would tell another sovereign country what rights their citizens should have. But I'll be damned if anybody's going to tell us in North America what rights we will have in the internet. And it is a clash of fundamental values. How will the internet be governed? And it was one thing for the internet to be governed by non-governmental organizations in some significant measure when the internet wasn't the critical part of the world economy that it is now. But the governmental role is a legitimate one. For example, no one in this room, I think, would dispute that governments have a role fighting child pornography, to take one of the worst aspects of how the internet can be used for an unattractive social purpose. Or perhaps some of you are libertarian enough that you believe child pornography is okay. I personally don't believe that it is, and I believe that government has a legitimate role there. But that doesn't mean that we don't have a legitimate role. So as we look on this slide, we see many of the institutions that you may think are entitled to be involved in the internet governance. I tell you that there's nothing that entitles that 10 years from now, or 5 years from now, or 2 years from now, unless we retain the confidence, if you will, of our national governments, first the United States government, the Canadian government, the other governments of the ARIN service region for my particular client, or as we go around the world, the intent of sovereign governments to permit non-governmental organizations to be involved in the structure of this. And let's face it, there are some governments are just more comfortable dealing with their brothers and sisters at a governmental level than looking at you and feeling that you are an important partner in the process of running the internet. You have to be at some of the meetings in Switzerland or around the world and listen to some of those governments when they speak almost derisively of the notion of a room full of people like you running the internet, even though that's how it's occurred. So what I want to start by saying is, before we get down to whether paragraph 9 of the legacy RSA is really stealing something that belongs to somebody, I want to tell you that there's a superstructure here of social concern that everything else is going to fit into. Let's talk a little bit about what's going on in the world. While we may be very comfortable in North America with distributed power, in other words, in the United States and in Canada and in other governments in this region, we're very comfortable with the distributed power, particularly in the United States, which I'm most familiar with the legal system. We believe in a limited government, and we believe in the right of the people to do certain things. Well, that's not true around the world. And so, for example, tiny Estonia, which is a country that was in the Soviet orbit for almost 50 years, when Estonia and Latvia and Lithuania and the other countries of Eastern Europe resumed their rightful role in Europe as a European country, there are people who don't like that in the world. And we all read earlier this year about Estonia's intention to be an e-government and to be an e-society, and how that came under attack from forces in another country, perhaps sponsored by a government and perhaps not. Certainly our intelligence services know more about that than we do, but one could presume that that sort of an attack is a very important issue. We recently watched as the Burmese internet was shut off to stem the flow of seeing what was actually happening in that country. And so there are real stakes in terms of who gets to govern the internet. And so let me just say, as a North American, we cannot tell Burma, Cuba, China, or any other country about how they should permit access to the internet within their country. That is their sovereign right. We may disagree with them about their internal rights for their citizens, but it is their right to do that. But it is also our right, I think, to defend our rights. So now that we've gone at a top-level political superstructure, I want to now come back down to issues that are more familiar to people in this room. Obviously, there's a coming crisis with regard to internet protocol numbering and ASNs. As you all know, we've been working under IPv4. The numbers that I'm showing there are a chart that was developed a few months ago, I'm sure it's changed since then, that shows the devolution of /8s in the IANA pool. And as you can see, there's a finite number of remaining unallocated IPv4 blocks. That number, it will decline to 0 at some point. The question is when that decline to zero will occur, but clearly there's a decline to zero coming. It may come in 2009, it may come in 2010, it may come in 2011, but it's clearly coming. May come next year, depending on the global needs as people wake up to this issue. So we have a situation where we have a good that we currently allocate based on principles that have been well understood and agreed within the internet community, where we're going to run out and there's going to have to be a substitution. So how serious is this problem? From my standpoint as a lawyer, not as an engineer, I think it's a very serious problem. If I tied it back to my previous political slides, if the internet community, the people in the NGO community, of which NANOG and the NOGs and ISOC and the RIRs and ICANN are a part, handle this transition badly, if the U.S. economy or other worldwide economies cannot grow appropriately because we mishandle this transition, I think there could be significant political consequences. In other words, I wasn't revving you up on the political part without tying it back to what I think is coming in this particular area. So if we don't, as the people who think we understand how to do this, and that is you, not me, run the internet properly, if we don't do this transition properly, we could lose the current governance model. So what has the ARIN Board had to say about this? ARIN is the registry, as you know, for North America, other than Mexico and some of the islands of the Caribbean, the service region that we have. There are 5 RIRs, as you know, all of them regionally based, broadly based. ARIN is very, very proud to have assisted the birth of both AFRINIC and LACNIC, who are our Latin American and African sister organizations. But for ARIN itself, ARIN was the first RIR, I believe, and I may be wrong about this, but I believe we were the first to basically adopt a position that said we can't be neutral anymore given the depletion of the IPv4 space. There is a need now to adopt IPv6 with all of its warts and ugliness and unintended consequences and costs and all of that. There is a necessity, according to the ARIN Board, to move to IPv6, and for people in this room to help their organizations do that. Clearly, the United States government, for example, is requiring its own agencies to have IPv6 plans, and I assume every sovereign nation is making its own plans to make sure that its economy transitions to IPv6. Now, that said, what I'm about to talk about in the rest of this talk represents my views of certain policy issues. They don't necessarily represent the ARIN position. I'll try and be clear when I'm speaking for ARIN rather than speaking for myself, but there's a modest freedom that comes for speaking for oneself as I assess some of the policy issues that we have to look at. Okay, so some policy proposals that are coming up now in the world to address the IPv4 depletion issue call for a fundamental change in our current system, which leads to the question, well, what is our current system? In RFC 2008, in I believe 1996, essentially the community developed a policy that said IP addresses and ASNs, IP resources, if you will, are not owned, okay? They're not owned, they're loaned. So, for example, when the IANA transfers to ARIN, ARIN does not own the IP numbers. And when ARIN issues an IP number to someone for their use, it is not an ownership issue that's being transferred. It is the right to use the services. That's what RFC 2008 said. You can look it up. I read it this morning again to make sure that I was okay on this. And I think fundamentally I want to bring you back as a lawyer would. Lawyers look at precedent. The precedent for this community is its adoption of RFC 2008 and RFC 2050. So let me ask the first question, and now I want some audience participation. How many people in this room know that John Postel was the key author of RFC 2050? Is there anybody out there who agrees with that statement, that remembers that time period? I see some. There's Paul Vixie. Do I see others? Okay, Paul Vixie is the only one who's either awake or not. Please, David.
Actually, the key author was Kim Hubbard.
Okay. Was Kim, I'm sorry? Well, Kim, indeed, has got her name at the bottom of it, but indeed, would you disagree with me, Joff, or my gentleman from IANA, would you disagree with me that John was very, very important in both the creation of the ideas around it, which are the best practices for the community? Please.
Go ahead.
I didn't recognize Randy. I asked you, David.
So John was a contributor. Kim was the primary author on the document.
Okay, good. All right. I'll accept that. Randy, did you want to change that?
They're correct.
Pardon me?
They're correct.
Oh, okay, good. Randy agrees that something I've said is correct once I agreed with David Conrad.
No, he said something basic.
Okay. No.
Sir,
but I agreed with
would
it.
remind you that I helped hire you.
Oh, well, and mistakes are made every day. So, now, we go on from there. I'd like to talk a little bit about what the terms of 2050 say, and I decided to add them to the slide so that while you're reading the USA Today on the sports page about the Rockies going to the World Series, you could look up and see that RFC 2050 contemplates that David Conrad, not Steve Ryan, I repeat, David Conrad, not Steve Ryan, has the right to claw back from people, ultimately, unused IP resources that have been issued where the where the use of them is invalidated, and so you need to be nice to David. I'm always nice to David. There is that first provision there about unused resources. The second provision that I'd like you to keep in mind is the right to transfer is limited by 2050 to transfers that are in accord with the policies of the registry. I see someone standing at the microphone, so I will stop and yield. I'm not going to yield all the time, but if I know the person and I like them, I'm going to yield. Go ahead.
Thank you, Steve. That means that I have to say, for the record, that I'm actually Suzanne Wolf, and I'm speaking only for myself at the moment. A style point. Not to interrupt, let's talk in terms of institutions rather than individuals when discussing our current mechanisms and situation. It's important to show the world, the webcast audience, the archive, that we're not talking about ARIN. Sorry, we are talking about ARIN, not Steve Ryan. We're talking about IANA, not David Conrad.
I think that's fine. I certainly agree with the first point about ARIN, not Steve Ryan. On the second point, you know, I do believe that governments, like when we have a president, we only have one at a time. He can be a good president or he can be a bad president, but he's still the president. And of course, David has that current authority. But I take your point.
Yeah, I just wanted that noted for the archive.
Depersonalization is an important issue.
You were saying what Rights 2050 said. 2050 didn't say David Conrad.
Okay. Thank you, Randy. With regard to oh, David, do you want to speak?
Yeah. So the section that you referenced in section 3 is actually talking about assignments that are made by ISPs to end users. It's actually not in reference to allocations made by IANA to the RIRs or allocations made by RIRs to ISPs.
And your basis for that, please?
Read section 3.
Well,
it's assignments, not allocations.
Okay.
And
all right.
with regards to IANA as an entity, IANA does not operate in a dictatorial function. We operate at the request of others.
All right. We'll come back to this point. On the transfer issue, the transfers have to be done consistent with RIR policy, and that's what's in 2050. Third, fee for service. One of the things that I think the RIR community has done is the fees, and I think this goes to something we're going to be talking about in a moment, the fees for the allocation of IP resources for the services related to that have remained relatively low. And as we push forward, you'll see that economists might, with a scarce good, want the price to rise and the quantity to be more limited. But at this point, the fee for services that are charged by the RIRs, however annoying to people, are actually quite small, and by order of magnitude could be raised significantly without actually affecting the price to consumers. In other words, as we look at the service bundle that's delivered to consumers, the cost of obtaining IP resources from the registries is an extraordinarily small part of the service bundle. So, the last item I want to point out in 2050, and this goes to what's going to happen in the future as we come to the end of time for new IPv4 resources, is there is also a command in 2050, which each of the registries is following in a different way, similar but different, that if you receive a false set of documentation, if you receive lies in the documents that are filed with you, you're permitted to revoke resources that are a result of fraud. So these are some of the provisions of 2050. I find David's reading of that paragraph perhaps more authoritative than mine, but I didn't read it that way, and we'll come back to that in a moment. So now, what are some of the policy proposals that are coming up, and how do they fit into the world that was established by RFC 2008 and the world that was established by RFC 2050, which currently are in many, many ways the governing standards by which the RIRs are still conducting business, or the IANA is conducting business. Well, there are some policy proposals that say we won't work on utilization anymore. We'll work on the basis of equality of regions. So, for example, even if several regions have a utilization need, that is, there are people who are waiting for addresses and need them for something that they could prove, we're still going to allocate equally to regions around the globe because that's fairer. So there are issues like that that would change the allocation method that's currently being followed, which is basically utilization. As each region needs a new block of IP addresses to distribute, it obtains that from the IANA. I think this slide says the same thing as the, let me see. So let's talk about markets. Let's talk about people who believe that there should be a sale permitted in a way, not of the fundamental right of ownership of the IP, although perhaps some people believe that as well, but the right, the bundle of rights to use the IP. There's some proposals to create a market for that. And again, anyone who's creating a market for sale and redistribution of IP resources needs to define whether they're saying that there's an ownership of that, which would be contrary to 2008 and contrary to 2050, versus a market which is not permitted right now by policy for the sale or redistribution of the limited right to use the IP resources consistent with 2008 and 2050. And again, the creation of such a market, of either of those markets, would be a fundamental change in current policy. Proponents of a market have the duty, I think, to come before you, the Internet community, and convince you that because of the current depletion of IPv4, the market is the best way to either cushion the transition to V6, to extend the life of V4 if that's a good thing, to reallocate underutilized or indeed not utilized V4 resources to those who could use them. There are pros and cons of a model. I am not here to tell you today that a model is evil and you should avoid it, nor to embrace it and say a model is, pardon me, I didn't mean to say model, I meant to say market, that a market is a great thing and you should embrace it, or that you should reject it. What I'd like to do is share with you some of the thinking from a lawyer's perspective about what the transition to a market would mean. Lawyers are very skeptical, if you will, of changing the legal regime that we are in. Currently, for example, ARIN has approximately 11,500 to 12,000 RSAs, registration services agreements, that permit entities that range in size and importance in the U.S. economy, for example, from the Department of Defense or Microsoft down to the smallest ISP. Those 11,500 contracts are all premised on the same rights that are described in RFC 2008 and 2050. That is, that there is no ownership of that IP by the resulting entity. In other words, the Department of Defense or Microsoft or the small ISP has no ownership right in those services, but is obtaining services that will be given to them for that period, and when they no longer need those services, they will return the IP resources to the community. So if we start by recognizing that the legal regime that's been created mirrors the policy regime that a room like this created, or that Ms. Hubbard and John Postel created with your consensus and agreement, if that is the case, then the legal regime is consistent with that. Now, it's very, very hard to say, for example, we're going to go to a market that will begin on X day and we will change, in essence, the rights that people have as a matter of policy and permit them to begin selling the right to use those services to someone else when you don't go through the registry. Because all of the current 11,500 contracts are premised on the transfer back to the registry of the IP resources before they're retransferred out again to the next party who's entitled to use them. Will a market help? I think I've tried to distill what are the best arguments for and against the market, and I have them with me. I didn't put them on a slide. Bear with me for a sec. Okay. Let me give you the best 6 policy arguments that I can come up with against a market. And then I'm going to give you the six or seven best arguments for a market in this area. The first argument, I think, against a market is that it will play havoc with the routing table. In other words, as you subatomize blocks and reduce them, there is a tension that is described in 2050 and in 2008 between the impact on the routing table and the smaller size of blocks. So clearly there's a point at which the market can't be permitted to drive the size of a block that would be routed without having tremendous impact on the size of the router that's needed in order to power this. That is not intuitive to a person who is not familiar with the architecture of the Internet. In other words, if you're a member of Congress or a member of the Parliament or the member of a normal legislative body, I don't think they understand the normal operations of the Internet and the impact on the routing table of that effect. And I think it's very important that when you speak to policymakers in any way, you have to educate them. The industry, the people in this room have to educate people in the top level of the corporate suite about the impact of this on the routing table as well. I think the second argument against markets is that the market will actually delay implementation of V6. In other words, if you're going to get to V6, there are some people who say you ought to get there quicker, that the transition needs to be shorter to V6, and that anything that extends the V4 marketplace might be a bad thing. And that can obviously be turned on its head, and I'll turn it on its head in a minute. The other part of the third argument against a market is that the transition will be harder if we permit the market to ameliorate the decision-making of people who want to stick with V4. The fourth reason against a market is it will result in a windfall that is inappropriate to legacy address holders, for example, who may have unused space that they obtained earlier, and where the market for a short period may reward people for those holdings which they haven't utilized. A fifth reason for being against the market is it could result in intercontinental or inter-region transfers. Generally, markets favor rich economies over poor economies. In other words, if you're an economist, and I've brought with me one of the most brilliant economists, and I'd like to introduce him to you. Professor Ben Edelman is right over here. Ben, stand up, please. Professor Edelman is known to many of you. He was one of the reporters on the early ICANN meeting. He was one of the persons who transformed what people were saying in a stumbling way at the microphone into a cogent argument that appeared on the bottom of the slide. Professor Edelman is a professor of business at the Harvard Business School. He has a PhD in economics. He has a master's in statistics, and he has a JD degree, that is Juris Doctor. He's a lawyer as well from Harvard. And he has been engaged by ARIN to provide advice about whether a market is inevitable for V4. What are the characteristics of that market, if it's going to occur, that are unattractive and might be ameliorated by policy decisions, and or how can the market be made to operate correctly if a market's going to occur. So ARIN, for example, is reaching out and using Professor Edelman to get some of these very good ideas about it. And I think Professor Edelman would probably be able to share with you, at least on this point, that markets favor rich economies over poor economies, that rich economies, if permitted the right, might cherry-pick IPv4 resources from the third world, and that might not be a very good result. And finally, we all know that markets, if not controlled appropriately, constrained by law or regulation, can lead to hoarding, speculation, and price manipulation. So we know that there are certain aspects of markets that can lead to unattractive behavior. Now, just to show you that I'm a lawyer and that I can do on the one hand and on the other hand, now let me try and be equally convincing that there are 7 reasons one might want a market. And again, as you can tell, I'm not here to tell you what the right answer is of market or no market, but let me give you policy reasons for a market. The policy reasons are: it encourages reclamation of underutilized or unused prior allocations. It will encourage IPv6 adoption by allowing a longer buffer period for IPv6 adoption. It will permit transfers so that the market can dictate what the highest and best use of an IP resource is. Another benefit of the market is that the market will substitute market power for stewardship in a meaningful way. In other words, people will vote with their dollars, and that will result in meaningful decision making. The market can deter bad behavior. In other words, somebody who tries to corner the market may end up like the Hunts, because what we know is that IPv4 may never be shut off but there'll be a period where IPv4 resources are considered more valuable, and then there'll be a period where their value declines. And if someone tries to corner that market, they may end up with a lot of IPv4 resources that nobody wants at the end of the day. So if you're for a market, you may decide that arbitrage is good. And if you're against a market, you could say that the speculation and price manipulation might be bad. So those are some of the thoughts that are rattling around on markets. Now, this brings us to legacy address space. And let me ask a question. How many legacy address holders are out there in the audience today? If you could choose to put up your hands. Okay, we have 15 to 18, maybe 20 legacy address holders. And I'm looking forward to having a discussion with all of you as the week goes on about anything I say here. What I am going to ask is that when we talk to legacy address holders, if you would agree to the following conditions. Will you agree that when you come to the microphone, you'd tell us how big an allocation you got and how much of it is not currently being utilized? That would be different than how much of it is announced. We'd be glad to take all of your questions then after that. Just a suggestion. Let me say that before the registries existed, before ARIN existed, before APNIC existed, and before RIPE existed, the first three of the registries, there was space allocated to legacy address holders, and, you know, it wasn't exactly the way lawyers do it. People applied to John Postel and or a series of government agencies for space, and they got it for use, and the terms of that are a little bit smoky and a little bit ambiguous, and so it's a little bit like if you're the one lawyer in a one-lawyer town, you're a very poor person. But if there are multiple lawyers in the town, and they can take different positions, then you could be a very rich lawyer. And so I think there's going to be a debate about what the rights and powers that were given to the legacy holders. What are those powers? What duties do they have, if any, to the Internet community? What rights do they have vis-a-vis the community? And we'll talk a little bit about this. I will say that in a recent agreement with the United States government, ARIN, by the way, provides resources to government agencies throughout its service region. And with regard to the United States government, the Department of Defense has signed a registration services agreement that has a groundbreaking provision in it, which says that the United States government, the Department of Defense, which heavily funded the creation of IPv4, they've said that they will give back to the community IPv resources that they no longer need. It's clearly within their control to decide what those resources are and when they'd give them back. But I think it's interesting to note that at least from a stewardship perspective, you know, not every U.S. government policy is something I'd like to defend up here, aka see the war. On the other hand, with regard to governance of the Internet, generally United States government policy has been very, very thoughtful, and I think this is a reflection of that thought. So, in the legacy address space area, it's very clear that there's a large percentage of the legacy address holdings that are not currently in use. If that's the case, then a market would entice potentially out some of that unused or underutilized space. And there are considerations about that right now. ARIN has had, I've had the joy. Is there anybody here from Microsoft? Anyone? I've had the joy of being the only lawyer in America who says, here's my service agreement, sign it to Microsoft. In other words, it's quite the reverse of the usual relationship one has with Microsoft. And I must say I've enjoyed that inordinately. And I have the same relationship to all of the other great American companies, whether they're Motorola or Hewlett-Packard or Oracle or outside of the technology sector. And it's always fun to have that sort of a policy. What we've done now is ARIN is proposing a legacy registration services agreement. And if you lay the legacy registration service agreement side by side with our current agreement that we make our brothers and sisters at Microsoft sign, you'll find that the legacy service agreement is very attractive to legacy address holders. And I mean very attractive. In the long run, what the legacy RSA promises is that if you sign up to be a part of the community, which legacy address holders currently are in the sense that they're receiving free services from registries like ARIN, that they'll get certain contractually guaranteed rights. And those contractually guaranteed rights include the promise that the community will not try in some way to invalidate their holdings of legacy address space that are unused. It basically requires that they pay $100 a year, which is the normal fee that we charge to make sure that we're in correct contact with a POC of a corporation. And it is truly, I think, if you reflect on the differences between the standard RSA and the legacy RSA, it's a very attractive contractual package. We can debate whether that package should be more attractive to legacy holders or more fair to the other members of the community who currently pay to sustain, for example, the WHOIS, or currently provide the IANA services. Clearly, the approximately 12,000 people who have signed RSAs with ARIN, for example, and similarly for other RIRs, they are paying to sustain the services that legacy address holders currently obtain for free. So as we look at this together, it's my hope that a good dialogue will result. Right now, that legacy RSA is posted. There's been, I've read, some posts that indicate, like the movie Dr. Strangelove, where they're talking about shelter space, that they're coming to take our shelter space away. We're not coming to take anyone's shelter space away. We're not coming to take anybody's legacy rights away. What we are providing, I think, here is a voluntary, totally voluntary package that addresses what we've been asked to do for the legacy address community that would provide strong contractual guarantees of future services. So I'm going to actually open this up. We have a good 15 minutes or 12 minutes, 15 minutes left. And if people want to debate the wisdom of any particular provision in the legacy RSA, I'm glad to try and address that for you. If I've said something provocative, as I obviously did earlier without realizing it by talking about people versus policies, you can feel free to take me to task. I appreciate the attention that you've given me this morning, and I throw it open to you now for discussion.
Good. And maybe I can start it off, Mr. Ryan. If, and others head to the mics and you'll be called upon to speak your piece. So given the description that you've made of the legacy RSA offering, it's not clear to me why ARIN would want to do that. Right? So what the legacy holders secretly believe is that you're coming to take their shelter space.
Right.
Right? And so why does ARIN want to do this if you get $100 a year and they get more rights and they get to keep all their space?
There is a benefit to the community that everyone agrees to play by the same rules. As we looked at RFC 2050, legacy holders who are receiving services ought to pay for those services, in my judgment. In other words, there's an inequity in that the smallest ISP is paying for the services that they receive, while legacy holders with a very large block are paying nothing under the current system. So there's equity, I think, in the package. But on the other hand, there's no reason for people to fear that their rights are being taken away. I think if you read carefully the rights that are guaranteed there, they're very much consistent with what we understood legacy holders indicated would be the right balance here. I will say that I've had a number of private communications. that say that the legacy RSA actually is too beneficial to legacy holders, that it is unfair to normal registrants, and of course we could debate that as well.
Mr. Houston.
Jeff Houston. I'm the person who authored the transfer policy proposal in the APNIC area, and certainly I've been looking at this for some time. One thing I noticed was entirely absent in what you said that I think is extremely relevant here is actually an observation about the politics and sociology of abundance and the politics and sociology of scarcity. We originally started this many, many years ago with indeed an attitude of 32 bits created so many addresses, billions of them, that giving it away was just fine. Abundance was the way we operated. And we established an entire framework around the distribution of these based on their abundance. A lot of the documents you cite were based on that artefact, that addresses were plentiful. We weren't rationing them. We weren't trying to figure out the relative need of one party or another, which is what rationing is all about. Since the internet bust, we've used the words internet and failure many times, and we're about to use it again, because this situation we're in now was never meant to happen. We were never meant to be in the rather strange place of running out of these addresses without a plan B already operating. We were meant to have done whatever dual stack was meant to have done to us. We were meant to have gone somewhere else long before today. We were never meant to be here. And what we're confronting is the exhaustion of a distribution framework. The RIRs actually had two roles, and we never quite understood the distinction between the two. They were operators of a distribution framework. We gave out addresses. But we also did something else which was implicit. We understood and indeed underpinned uniqueness. It's the registry that counts. My right to use an address is not a secret I mumble to myself in some deep and dark corner. My right to use an address and your right not to use it is based on a public attestation in a registry that that address is associated with me at this point in time. That's a very, very important artefact, because that's what makes routing work and that's what makes addressing work. Registries give you that public attestation of uniqueness of right of use. So that's what we're going to have to preserve through this rather deep chasm of failure we're heading into. That's the essential thing. Now, when we run out of addresses to give away, all of your product managers are not going to say, oh, dear me, time for another job. They're still sitting there dreaming of the next wonderful product and have no idea what you're talking about when you're going to run out of addresses. They need addresses. And when the registries have no more to give away, what are you going to do? Yeah. Look around you, because that's where the addresses are going to come from. And how do you know when you look around you right here and now that the person who's offering you some has the right to be able to do so? Where are you going to look? Who are you going to ask? You're going to take their word for it? In which case I've got a huge bridge I want to sell as well. At some point you need to understand where you're going to look for authority on uniqueness. At some point you need to understand that the registries are there working for you. That's why the RSA agreement actually works in some ways. It's trying to say, look, the real thing here is about uniqueness as a particular function and a supporting attribute of our entire framework. And whether you're going to run V6 tomorrow or whether you're going to wait for another 10 years and just watch the wreck that unfolds is your call. But no matter what we're going to have to understand is that the current framework is changing in terms of distribution. But behind that, the absolute reliance on a registry system that gives you a firm and solid undertaking of uniqueness of use is absolutely essential for this industry.
So let me just say something. Jeff Houston is one of the most charismatic figures we have, and like an American congressman, he used his entire 5 minutes and made a statement, and there's no question, and I'm grateful for that.
Randy Bush, IHHF. We usually say where our rice bowl's filled, and we should realize Jeff is from a registry. I wish to declare my conflicts. I also contract to a registry. I am also a legacy holder, and I'm also working on the registration certification software on which Jeff, and as is Jeff, on which some of this transfer stuff, among many other things, will be based. A couple of points. Number one is the trading is not what's going to kill my router. What's going to kill my router is the run out of space and the fragmentation that's going to happen no matter what. But I'll beat you to death on that this afternoon in my prezzo. Number two is ARIN gives out over 75% of its resources to the top 10 holders. So don't tell us how nasty it's going to be if the developing countries get some address space, that those top 10 holders in those countries might utilize it. That scare tactic just don't float. But my real little thing I want to underline is, I think Jeff Schiller said it very well on the ARIN PPML list, is that with the RSA you're proposing for legacy address space, there are really two separate things happening. One is trying to get the legacy holders in, get the stuff registered, get them to contribute some for the registered, get the who is data correct, et cetera, and try to get them to pay for some of the services they're getting. I have no problem with that. And if it's going to be $200 instead of $100, I have no problem with that. The second part, and is totally intermixed with your registry services agreement, is all about rights. And do you happen to have Section 9 available you could put on the screen, since the last thing you said was it doesn't speak to or ameliorate in any way, excuse me for paraphrasing, I don't really remember well at my age, the rights of the legacy holders. And if you could put Section 9 up there.
I can't, but I can read it to people. Would that be helpful?
Please.
Okay. 9 says no property rights. Legacy applicant acknowledges and agrees that the number resources are not property, real, personal, or intellectual, and that the legacy applicant does not have any property rights in or to the included number resources included but not limited to this legacy agreement. Is that enough, Randy?
That's enough.
Okay.
Because that does speak to what the rights are. I'm not arguing whether or not we have property rights. I don't think we should have that argument here. But the fact is, it does make a very clear statement in amelioration of what the legacy holders' property rights are. So I believe your last statement is quite incorrect.
All right. Randy took 6 minutes, approximately, and I appreciate that he didn't ask any questions either, but I'm going to comment. Randy, would you mind, and I don't know how you feel about this, so you can say yes or no, would you tell people how much of your legacy address block is being used, or, okay. So,
the question is, would ARIN tell us who the top 10 people are who get over 75% of the address space?
First of all, I don't know if that figure is correct, but assuming it is correct, why don't we raise it at the ARIN meeting, and I'll certainly look at whether there's any reason why we can't tell you. And if we can, I'd like to. With regard to paragraph 9, which you just asked me to read and that you feel is somehow inappropriate, obviously, or inconsistent with the philosophy that I expressed, let me just say that paragraph 9 would put legacy address holders on the same footing as the other 12,000 people with regard to acknowledging that they do not own the IP as property, but they own the beneficial right to use it. And I think that's perfectly appropriate, and I think actually it's in many ways necessary to level the playing ground between legacy address holders and those who are within the system.
We're running out of time, so we're going to do these two who are at the mic and then wrap up. Yes.
Andrew Dahl, I work for Perkins Coie. We have a legacy /24 that is largely utilized. The question I'd like to ask is the legacy RSA, which I appreciate that the ARIN Board went and produced and actually published. One of the things that I think has come out on the mailing list, and I realize this is not the same forum as the ARIN meeting, but we're here discussing it, is that ARIN has a very strong ground and bottom-up policy decision process. And one of the things that's come out in the meeting is, or on the mailing list, is that this is a draft of the policy, or this is the policy that legacy space holders will have to sign. The question I have is, if legacy space holders provide constructive feedback and, rational changes that they think should be made, will ARIN and the Board of Trustees go back and make some revisions to this document and then produce one that we think, more people will be willing to take forward to their people who have to sign this? Because I don't want to throw out the bottom-up policy process that we have all been working through for a number of years, when this is the first time that we are really trying to get legacy holders to come to the table. I think we need to respect their opinions and take their input, and if there is constructive changes, let's make them, and let's produce a document that a lot of people will want to sign and become members and more active contributors of the community. Thank you.
So there's two important responses from that. First of all, it is the intention of the ARIN Board to evaluate the input that they receive in the next few days and perhaps even weeks, and then to finalize the RSA. In other words, we're not open for business for signing, although I can make a special deal for anyone who would like to do that in the interim. I think it's a very important point. Like an administrative procedure rulemaking, you put out the proposed rule and then you ask for comments about it. So I think with regard to this, the ARIN Board is very open to that. Let me say ultimately, though, that the agreement that ARIN puts out there has to be the decision of its board, because you can't ask people what contract they would like. Ultimately, people may differ on their opinions about that contract. It's not a plebiscite issue where proposals for policies that govern the community can be. So there's an overlap of what's in a contract and what is policy, and the policy has to be consistent with the contract, or the contract has to change. We have had 9 versions of the ARIN RSA. Obviously, the RSA has changed and morphed over time as new thoughts and challenges occur. One of the things I think the ARIN Board is deeply committed to is that whatever is the true version 1 that is signed by legacy address holders who want to participate in this RSA exercise for the legacy holders, we will always agree that if we make a change subsequent to that that is more beneficial to the legacy address holders, we will allow the first people who sign to have the benefits of any changes later that they wish. And that would be a wish, not required. So it would always be the choice of the first generation legacy address holders who sign.
Okay. Yes, and the last question.
Actually, a statement and then a question. As one of the authors of RFC 2050, I have to say that one of the most stunning aspects of the discussions that have occurred on the issues relating to addressing recently has been the assertion that somehow 2050 is a legal document, or the implied legality of that specific best current practice. When 2050 was written in 1996, the RIRs were just becoming established. And it was known at the time of writing that it was a current practice. And if you read 2050, there is a statement at the beginning, excuse me, by the IESG saying they will revisit this to see if it currently applies in 1997. In 1997, when that revisiting occurred, it was determined that policy regarding addressing should not be made within the IETF, and it should be made within the RIR structures. The fact that we're trotting out 2050 as some sort of writ from heaven by the Saint John Postel is just very surprising to me. The question is, in 2 years...
Well, will you yield before I ask?
Sure.
Let me just make a quick point. I think the importance of 2050 and 2008 is to show the continuity of the current legal regime with the policies that were approved at that time as standard setting. I don't remember that those standards have been ignored thereafter by the RIR community. In other words, the RIR community now can depart from those. They have policy bottom-up policy processes to do that. But I think this is an ethical, not necessarily always a legal issue, okay? A lot of people got resources from John Postel under understandings that are not written down. The lawyers didn't write the contract between Postel and the legacy address holders. So what I find interesting is legacy address holders saying, treat me like a lawyer, when frankly John Postel did not treat them like a lawyer at the time. There were certain common understandings, and what I've tried to do in using 2050 is to drive at what were those common understandings. And so I'm not citing it as a legal document, but frankly as one that describes, I think, the ethical climate in which the legacy address holders received their grant of IP resources.
All right. So, yeah, very quickly. So in 2 years, by reasonable estimates, the IPv4 address pool will be consumed. You do not, apparently, at least from the slides that you presented, believe that in a market is the right approach to deal with the post-run-out environment. What do you suggest as an alternative?
I've tried to make clear, actually, that I was trying to present a balanced set of the views which I thought might help people. I'm a lawyer. I do what my client tells me to do. My client, which is ARIN, has not directed yet which direction it's going in, which is why you got on the one hand or the other hand. I think as the debate continues, I think it is very, very helpful for the community to reflect what its consensus is so that the ARIN process can develop policies intended to deliver a market that works, if that's the intention of the community, or something that will transition very quickly from IPv4 to 6 without a market, if that's the intention of the community. So truly, I don't have a personal position on that yet because my client hasn't told me it.